Chapter 9. How to spot issues and what to do once you spot them. Now that you have seen what issues, or what we have called forks, look like, there are only two questions you need to answer to ensure your place at or near the top of your class. First, what can you do to learn to recognize forks when they appear on your exams? And so do we, that it's not enough for you to sit and read someone else's description of forks in the comfort of the library. You need to know how you can learn to spot them on actual exams. Second, and equally important, you need to know what to do with the forks when you find them. Once again, it won't be enough merely to tell the professor you have spotted an issue. We're going to tackle these two crucial questions over the course of the remaining chapters. But if we use the same detailed style that we used in Part I, this breezy how-to book would read more like a 19th century treatise. So we are going to proceed along the following lines instead. In this chapter, we will concentrate our energy on two key areas. First, what lessons can we draw from our chapters on forks that will help you tailor your studying with an eye toward exam preparation? It stands to reason that the study techniques you developed as an undergraduate are suboptimal from a law school exam standpoint, since your earlier exams were very different. Second, what are the crucial components of writing exam answers that help you move forcefully from spotting forks to analyzing issues and suggesting results? We think each of these topics is large enough to deserve more than what we say in this chapter. That's why we include in Part Roman 3 a set of test-taking tips that will provide illustrations and extensions of the key points we make here. These tips alone can take you a long way toward better performance. Two myths, however, are particularly pernicious and deserve special rebuttal in this chapter. First, many people believe there is no way to learn to spot issues. As we will show, this is utter nonsense. Second, many people speak as if exam writing involves little more than the application of rules to a given set of facts. If you've stuck with us this far, you already know that this can't be true. There is so much ambiguity in any rule structure that rote application will seldom get you anywhere. Indeed, we hope that after reading our criticisms of what is known as the Iraq method, you will never let anyone around you say something so foolish again. But if spotting the issues isn't enough and rote application won't work, what will? In a nutshell, we want you to see every issue spotting problem as really asking two questions. The first asks you to identify the forks we have described so extensively. This chapter, together with what you've learned from the book so far, should give you the tools necessary to become adept at that. The second question asks for an analysis of which road the court should follow. The challenge is to make the transition from noticing, for example, that a case might be read broadly or narrowly to arguing that it should be read broadly or narrowly. We introduce that topic in the second half of this chapter. The multiple array of should arguments, however, is so important to top performance that we leave a complete analysis to the next chapter. You'll need to read what it feels like to be a czar of the universe before you are ready to tackle your next set of exams. A. Issue spotting. 1. What the course will tell you if you listen. A. Class notes and outlines. You have heard from your professors and countless other sources, and you'll hear it again from us, that you cannot prepare adequately for exams merely by reading commercial outlines or even outlines prepared by other students. You are now in a position to understand why. Part of the reason, of course, is that no outline can tell you how to be creative in responding to the new situations your exams present. The real problem with most law school outlines, however, is that they are organized solely around topics and rules. Your contracts outline will tell you about formation, breach, and damages. Your property outline will discuss types of ownership. Your torts outline will teach you the difference between strict liability and negligence, between directness and foreseeability as tests for proximate causation. Your criminal law outline will review types of intent. You need to know all these things. But as should be clear from fork proliferation, they are not enough. You need to know not only the rules, you also need to know all the places where the rules don't yet settle all the questions likely to arise. There's no reason to expect someone else's outline to answer these questions. That's not what outlines are intended to do. Students often think professors are being elitist, pretentious, or worse when we tell you that commercial outlines aren't the answer to your prayers. That's because you are reading our criticisms through old lenses. We don't mean to imply that you can't often trust commercial outlines to give you accurate statements of the law, although clearly some are better than others. Nor do we mean to suggest that the outlines don't sometimes do a better job than even some of us can in presenting the existing material in an organized fashion. The big problem is that if you think learning the material is all you need to do to perform well, then you haven't been paying attention so far. We recommend an additional, not a substitute approach to outlining your classes. Rather than simply passively accumulating the information presented, you should employ the techniques we have described in Part I. Some ideas for such outlining might include: find some statutes discussed in the course and identify the underlying purposes of the statutes. But don't stop with a list of purposes. That's what other outlines do. Instead, force yourself to invent situations where the multiple purposes compete with each other and consider how a court might resolve these situations. Put those examples into your outline. Find those areas of your course that are organized in what we refer to as the gantlet structure, as a series of elements that must be satisfied before one party can prevail. Put in your outline examples where it's not clear whether each of the elements is satisfied. Read over your cases and include in your outline not only what they settle, but what they leave open. This is a fundamentally different strategy from what you'll find in almost any other discipline. You want to study what you don't know as much as what you do. Outline your course around foundational forks in the law and recurring forks in the facts. Any respectable torts outline would describe the differences between strict liability and negligence, perhaps the crucial fork in the course, and would also detail some of the underlying policy arguments that might push courts toward one doctrine or the other. But in your getting to maybe outline, you would go beyond the definitions of strict liability and negligence, which you would have already learned by heart, along with virtually all your other classmates. You would identify the strict liability vs. negligence fork as one of the key choices the tort system faces. You would then list the places where that system appears to have chosen one or the other, and attempt to see where ambiguities still arise. Can you broaden the lead case on strict liability to cover handguns or snowmobiles? And what are the key forks in the facts? If there's strict liability for products, for example, is a genetically engineered vegetable a product? How about a cloned sheep? Finally, the best advice we can give for outlining is to think of yourself not merely as responding to, but inventing hypothetical. Those long exam questions from prior years that you should be poring over may appear daunting. Whatever are you to do with all that ambiguity? You know now, however, precisely where all that ambiguity comes from. If you practice writing some questions of your own, you'll put yourself in the mindset where rules that seemed clear may suddenly seem more ambiguous and open-ended. This will mean you are surely on the right track. A similar point should be made about class notes. When you sit in a lecture during undergraduate school, your vision of the professor may be of someone who has information to impart. If class discussion digresses from the professor's main points, you may find yourself nodding off, or in any event, not taking notes anymore. Law professors too have information to transmit, but that's not really the point of a law school class. Instead, the class discussion is designed to highlight ambiguities and alternative perspectives. As each student raises yet another possibility, the professor will keep pushing for more. It's not crucial that you take down every word. But as you are taking notes, one thing to look for is how ambiguities in the material opened the discussion in the first place. Why wasn't the case you are discussing open and shut? Why does the professor think it worth considering an alternative point of view? The places where the law is unclear are as important for your studying as even more important than the places where the law is clear. There is also every reason to believe that class discussion will provide hints about the nature of your exam that will help you spot issues. One common class technique will be for a professor to ask whether two cases decided by the same court are inconsistent. A long discussion may then ensue in which some students argue that the cases can be reconciled. Other students will suggest no reconciliation is possible. Many students are then annoyed if the professor fails to adjudicate between the student camps. If the professor doesn't tell the class whether the cases are or are not inconsistent. Many students feel the class had no resolution, and nothing was learned to go into notes or an outline. The contrary, however, is true. Emphasis on this particular inconsistency means the professor believes it's a pressure point for future legal development. If the professor is astute, the tensions she identifies may eventually give rise to actual disputes you'll confront in legal practice. But if you are astute, you'll watch for this inconsistency to show up even sooner on your exam. B. Themes and issues. As former college students ourselves, we have enormous sympathy for a certain sense of shock that strikes people as they move from undergraduate to law school. University courses often focus on big themes: the shift from classicism to romanticism, the clash between fiscal and monetary policy, the People's Congress vs. the imperial presidency. There's a sense of loss in giving these up for a narrow-minded focus on the exact provisions of the UCC or the Internal Revenue Code. A good law school course, however, quickly restores a student's faith in the intellectual challenge of her chosen profession. There she'll hear discussions of themes every bit as large as those encountered while an undergraduate. Criminal law may involve deep questions of free will and determinism. Contract law may pit notions of paternalism against a so-called free market. Tort law may match spreading losses against notions of individual responsibility. The pain is thus perhaps doubly great when you turn from your class discussions to your exam preparation. You may say to your property professor, "All semester long, we had this great conversation about the balance between protecting investment and encouraging competition. And now you want me to tell you whether some silly covenant touches and concerns the land." More generally, you may legitimately wonder why so many of your classes focus on big themes, yet your exams are mostly fact patterns that require only issue spotting and analysis. And if you wonder too much, you may begin to tune out discussion of themes altogether, so as to focus on what you think you need for top performance. We urge you not to make this mistake. The broader themes your professors build into your courses are directly relevant to issue spotting and analysis. You just need to know where to look. The whole point of our discussion of forks is to illustrate how many places the law leaves room for argument about the right result. And what makes the law so grand is that once the argument has begun, it's impossible to keep the themes out. Even the silly question about whether a particular covenant touches and concerns the land may directly invite a discussion of the very theme, investment vs. competition, that our hypothetical student felt was the best part of the class. Suppose the covenant placed on the land by the seller requires the new owner not to use the site as a research facility. Assume that such facilities are unlikely to produce more noise or traffic than the other uses of land in the area, and that the seller's sole purpose for including the restriction was to foreclose competition with his own research facility on an adjacent lot. An exam analysis of whether the covenant touches and concerns the land might start with familiar interpretive issues like whether enforcing the restriction must safeguard the seller's land from physical consequences, or whether any effect on the market value of the seller's land is sufficient to meet the touch and concern test. But you'll miss the whole point of the question if you don't see how this interpretive issue is linked to the broader theme. A pro-competition court will want new research facilities to be built, and thus may look skeptically upon the seller's efforts to satisfy the touch and concern requirement. But a court eager to protect seller's original investment will be much more open to arguments that the touch and concern test has been met. And this property example is the norm, not the exception. Nitty-gritty disputes about doctrinal issues that appear on exams are almost always connected to the big themes of the course. Whether an actor in a movie possesses a criminal intent when he strikes the victim and causes harm during a scene is the kind of question you might find on an exam. Yet you can't answer it fully without grasping broader themes of criminal law. A torts exam, as we've noted before, may ask whether a landlord is responsible for burns caused when the lack of hot water leads a tenant to boil water and accidentally spill it. You can't answer questions like this without knowing rules uke, the doctrine of proximate cause. But your answer will also suffer if you don't see that determining whether the landlord should pay raises the issues of fault, loss spreading, and responsibility that have been the larger themes of your course. If you simply write an essay on those themes when responding to an issue spotter, you will do poorly indeed. And in that sense, law school does ask for different responses than an undergraduate essay on classicism vs. romanticism. But the themes you study are nonetheless crucial to top performance on issue spotters. Indeed, you might use them to help predict the particular issues the professor finds worthy of treatment on the exam. Above all, pay attention when your professor or your classmates try to link doctrinal issues to the larger themes and issues you came to learn in the first place. That's what a first-class legal education is about. And that's what you'll find tested at exam time. See, old exams and study groups. The kind of outlining and study of themes we describe above is not easy. But here we have not just good, but very good news. In many cases, your professor will have done a great deal of the work for you. That's because you'll often find copies of old exams on file in the library. If you care about your performance at all, and we know you do, or you wouldn't be reading this, you simply cannot pass up the opportunity to review carefully your professor's old exams. You'll hear this from others, and because it's so important, you'll hear it from us again. But here we want to make the case explicitly in terms of our forks approach. Your professor may have taught the course several times before. In each old exam, she will have had to invent problems that present precisely the kinds of forks we identified in Part I. It's good practice to learn to identify these forks, simply because it will help you learn to hunt for issues, rather than merely spinning out rules. But even better, it's more than likely that some of the forks you find on old exams will show up again on yours. Most professors have particular forks they find especially interesting, or at least useful for writing exam questions, and they are not shy about repeating them. So when you read over old exams, it's not merely to get practice in the abstract, but also to teach yourself some of your professor's patterns. In writing this book, each of us read over several exams given by the other. We're sure we could do a lot better on another of those exams now than we might have cold turkey. Even the most energetic and creative professors, who think they are doing something new every time, in fact tend to fall back on old habits like a poker player who can't help making a certain expression every time he has a good hand. We urge you to bring along getting to maybe when you sit down with your old exams, so that you can explicitly look for the kinds of forks we describe. Don't worry, like Waldo, they are in there somewhere. But we urge you to bring along something else as well. Your classmates. Once you see that exam preparation is as much about hunting for things you don't know as memorizing things you do, you can see much more clearly why studying alone may not be enough. Finding those forks is difficult the first time through. If you do it with friends, each of you will find some forks the others don't. So by the time you get to the exam, you'll have seen enough of them so that the ones actually tested will either be ones you have encountered before or sufficiently similar that you'll be likely to recognize the pattern. 2. What the exam will tell you if you let it. No matter how well prepared you are, and no matter how many times you have read Getting to Maybe, the exam setting is likely to present unforeseen issues and difficulties. In Part Roman 3, we provide some practical tips on how to handle the experience. Here, however, we want to offer more substantive advice on several general techniques that will help you find and organize the forks. A. Map the parties' claims and conflicts. We know you have read countless exam guides that have told you to pay special attention to the parties described in the question, and who has what claim against whom. You are now in better position to understand why that's so important. It's the conflict between parties, like the conflict between Fred and his neighbors in the previous chapter, that creates all the forks in the first place. There's only a fork in the law, like a dispute over which of two rules to apply, when it's in one party's interest to apply one rule and another party's interest to apply a different rule. Paying special attention to the parties and the nature of their conflicts will thus almost always help get you started on issue or fork identification. We recommend thinking through your exam problems from the perspective of each party. If the plaintiff says this about the law, how will the defendant respond? If the defendant characterizes the facts this way, how will the plaintiff characterize them? This will get you into the right frame of mind for aggressively identifying and analyzing the relevant issues. There is also a role for good old-fashioned black-letter law in all of this. In most of your courses, you will learn the gauntlet of conventional elements of various claims and defenses. The classic example is the doctrine of adverse possession, that old chestnut from the property course, the 7 elements of which open, hostile, continuous, etc. are memorized and forgotten by generation after generation of law students. Most students enter law school under the impression that what they're going to have to do for 3 years is memorize lists of this sort, and, dull as that may sound, many are more than a little disappointed when they find out that their professors want them to focus instead on cases and hypothetical that test the meaning of this element or that one and its application to exotic facts. Does mooring a sailboat at a seemingly abandoned dock near your beach house for 8 summers constitute continuous use? If the farmer waves and smiles at your kids as he blithely plows a portion of your land, is his incursion hostile? Accordingly, it won't get you very far on an exam if you simply copy a list of elements into your blue books. But what your list can do is provide you with a useful map as you search for issues buried like treasure in your exam questions. To continue our example, an excellent way to go about identifying the issues in an adverse possession hypothetical is to work your way fully through the list of elements as you sort through the facts presented, looking for forks and ambiguities. The list may also provide you with a good way of constructing a roadmap for your reader. First, I will discuss whether mooring the boat during the summer constitutes continuous use. Then I will consider whether the use was open, etc. The point, then, is not to regurgitate the list, but to use it. B. Don't stop with the first issue you see. Apart from finals, perhaps the most anxiety-provoking experience for the typical law student is the first-year orientation party. A common strategy for coping with this peculiar rite of passage is to cruise the room looking for a familiar face in the sea of strangers, ideally someone you knew from undergraduate or high school. But desperate times call for desperate measures, so even someone you just met earlier that day will do. This start with the familiar strategy can provide some comfort and, as you are introduced to your friends' friends, and then to their friends, a base from which to begin working the room. But it can also be self-defeating. Thus, if you spend all evening sticking like Velcro to the one person you already know, it's going to be a mighty dull party for you as well as for the object of your anxious embrace. When we were in law school 1,000 years ago, we called such persons Klingons, and we learned to watch out for them at social functions. You may be surprised to learn that the anxieties of law school finals drive some students to adopt a strikingly similar strategy on their exams. Faced with the daunting task of analyzing a dense 1.5 to 2-page single-spaced hypothetical involving, for example, a multi-vehicle disaster and a cast of dozens, these students panic and quickly scan the question for anything they might recognize. They focus a laser beam on the first familiar issue they see. Aha, there's a contributory negligence vs. comparative negligence issue, and embrace it to the exclusion of a veritable glut of other issues lurking in the facts, e.g. issues involving negligence per se. Inviting rescue, proximate cause, multiple causes, damages. Like the social Klingon, the exam-taking Klingon is only searching for security in an extremely discomforting setting. But the exam-taking Klingon isn't any likelier than his social counterpart to be happy with the results of his efforts. See, if the answer seems too easy, it probably is. Assume you encounter a hypothetical on your contract's final that goes something like this. Seller agrees to supply widgets to buyer for $5,000. Seller breaches the contract and refuses to part with the promised widgets. Buyer purchases the widgets elsewhere for $600,000 to meet her pressing needs. What are buyer's damages? Under UCC 2712, buyer is entitled to the difference between the cost of cover, i.e. the cost of purchasing replacement goods, and the contract price. Accordingly, The answer here appears to be pretty straightforward. $600,000 $500 equals $100. But what's wrong with this picture? In a nutshell, it's this. Law exams almost never test anything as easy as the ability to subtract $500,000 from $600,000. So if you think that's the answer, chances are you haven't yet fully grasped the complexity of the question. We appreciate that you may be tempted to stick with $100,000 despite this warning. After all, simple subtraction is something even the most math-anxious among us can handle. While the rules governing, for example, a buyer's remedies under the UCC may seem utterly confusing in contrast. But when an answer seems that easy and straightforward, there is almost surely an issue lurking in there somewhere that you missed the first time through. Here are 3 specific ways you might go about spotting it. 1. Retrace your thinking step by step. One of the most effective strategies for spotting issues is to think the problem through once again and undertake a careful, step-by-step audit of your initial analysis. To continue with our widget sale example, your rethinking might go something like this. Under 271.22, buyer is entitled to the cost of cover less the contract price. The facts state that the contract price is $500,000. What's the cost of cover? Sub L of the provision defines cover as a reasonable purchase of substitute goods. Buyer bought substitute widgets here for $600,000. Is that a reasonable purchase? Well, we don't have many facts about the purchase. All we really know about it is the price buyer paid, which is $600,000. Is that a reasonable figure? How would know? There's nothing in the facts like a market price to compare it with. Wait a minute. I can compare it with the contract price, and it is a full $100,000 more than $500,000. That's 20% higher. That's a lot. Maybe the issue is whether the price is just too high to be a reasonable purchase. Chances are the ability to spot and grapple with this reasonableness issue is the fork in the facts that the professor was attempting to test with her question. And retracing the analysis in this step-by-step fashion is a good way of finding it if you missed it the first time. 2. Force yourself to argue the other side. Another effective strategy for figuring out what you missed in a question is to imagine that you are the lawyer for the party who has the most to lose from the seemingly easy answer. Suddenly, what seemed to be a virtue in your original answer, i.e., that it is easy to subtract $500,000 from $600,000, is outweighed by a vice, i.e., your client stands to lose $100,000. What can you do to reduce or minimize your client's loss? Just as retracing your steps can reveal questionable assumptions, attacking an answer from the other side can achieve the same purpose. Seller's labor is likely to react skeptically to buyer's claim that a figure 20% in excess of the contract price was a reasonable cover. And that is precisely the sort of skepticism that the professor is looking for and likely to reward on your exam. 3. Work out your analysis on paper. Don't let the way we've divided up this chapter fool you. Spotting issues on the one hand and dealing with them in an answer on the other are not always discrete phases of exam writing. Indeed, the first 2 suggestions for ways to spot additional issues, i.e., retracing your thinking step by step and forcing yourself to argue the other side, are approaches that may yield better results if you do them on paper than in your head. For many of us need to see whether it writes in order to figure out what we think. Moreover, there's no better place to do hard thinking about an exam question than right there in the blue book, where the professor can see it and reward it. To continue our example, an answer that begins with a frank admission that $100,000 is too easy and proceeds to discover the reasonable purchase issue, either by re-examining the initial assumptions or by attacking them from the other side, is the law school equivalent of the return of the prodigal son. Since most law professors care more about the quality of your analysis than the accuracy of your answers, you may well get more credit by showing the professor how you found your way back to an issue than would an answer that simply spots the issue and moves on. D. If you finish early, check your work. One of the most common characteristics of law exams is that they ask you to do about a week's worth of analysis in 4 hours or less. We don't defend that tradition indeed. We think there's a lot to be said for using the extended 8 to 48-hour take-home exam instead. But the point here is that, with the rarest of exceptions, your professor won't give you anywhere near the time that even an experienced lawyer would need to offer a thoroughgoing and competent analysis of each question. Accordingly, if you finish an exam early because you think you've said all there is to say, you are almost surely wrong. Once again, you may be attempting to transplant undergraduate test, taking habits to the law school setting. And once again, you would be making a serious mistake. The point of rechecking your answers on the memorize and regurgitate college exam is to make sure that your answers are right. Once that is accomplished, there is little to be gained by sticking around for yet another read-through. But the point of rechecking your answers on a law exam is not so much to make sure that they are right. Once again, there is frequently no right answer to a law school exam question, and even when there is, most professors are more interested in how you got there than in your doctrinal accuracy at the bottom line. What you should be doing instead is carefully rereading the questions and your answers, and if time and exam instructions permit, going back through your course outline to see whether there is some issue, some argument, some angle, some complexity you missed in your analysis. On the basis of the thousands of exams we've graded, we'd say that the odds are better than even that you missed a lot the first time around, and about 100 to L that you are missing at least one issue or argument that the professor thinks is extremely important. Wouldn't you rather figure that out before the grader does? B. What to do with issues once you spot them. 1. You already know more than you think you do. Here's more good news. Although mere issue spotting will seldom be enough for an A, top-notch issue identification will persuade most professors to look more favorably on your answers. That's because issue recognition has been a key factor in exam grading since long before we had the pleasure of enduring our own exams as students 20 years ago. As a senior colleague put it to us early in our teaching career, you've got to test issue spotting. How else can you tell how smart they are? We were skeptical then, and we aren't persuaded now, that issue spotting measures intelligence. We think it's more likely that the skills for identifying issues are poorly taught in many law school settings, leaving most students to the luck of their own devices. That's one reason we wrote this book. Indeed, doubts about issue spotting as a measure of performance have led some professors to write exams that emphasize analysis and argument instead. Be that as it may, however, issue spotting remains the sine qua non of successful exam performance, if only because in most exam questions, seeing the issue is the first step toward knowing what it is you are supposed to analyze or to argue about. So your tour through Part I has already taken you a long way toward the finish line. The patterns we identify there will make you better at hunting for Waldo. Better still, we hope, is that the Forks lexicon you have been learning will help usher you down the road of analysis and argument. That's because virtually every fork we describe begins with a conflict in which you can safely anticipate that the arguments for the two sides will flow nicely out of the issues you spot. To see how and why, let's go back to our tried and true tricycle in the park. Consider the following two answers to whether it's banned under the No Vehicles statute. Answer #1. It's not clear whether the tricycle is prohibited since the terms of the statute could be read to cover it or not. Answer #2. Determining whether the tricycle is banned from the park depends on whether we stick to the state's plain meaning or delve more deeply into statutory purpose. On the plain meaning view, the tricycle would seem to be banned, although even that's not clear because some meanings of the term may require things like carrying passengers that a trike might not do. If we look to the rule's purpose, we need to examine further which of the many potentially competing purposes a court may find decisive. We're sure you see that answer #2 is superior. But let's focus for a moment on why that is so. First, by sticking to a general description. Answer #1 comes up with only one issue, whereas answer #2 spots at least three. Plain meaning of the rule vs. its purpose. Competing meanings of vehicle. And competing purposes of the prohibition. By the way, did you see the linked forks? So, on issue spotting alone, answer #2 is miles ahead. Answer hash 2's second advantage, however, is even more decisive. You've heard repeatedly since you entered law school that your professors want analysis and argument, not just issue spotting. Answer hash 1 doesn't advance that endeavor at all. By contrast, answer hash 2 is aimed precisely at providing a blueprint to construct the analysis and arguments your professors are looking for. That's because stating issues in terms of forks uke plain meaning vs. purpose tells you right away that each party, presumably the government vs. the tricycle rider's parents, has an argument available to promote its side of the case. 2. From issue spotting to issue analysis. Thinking of issues as forks in the road will help you improve your analysis in 2 ways. First, you should ask yourself, what caused the road to split in the way it is? Second, you'll want to know, where will I end up if I go one way or another? Keeping those questions in mind is key to good exam writing, as we hope a return to our familiar artist Epitron example will make clear. Recall that Paul Patron offers Arlene Artiste $10,000 to paint a portrait of the Patron family, and, in response to her unwillingness to commit to a completion date, states that he wants a portrait, not a commitment. After Artiste spends numerous hours doing preliminary sketches, but before she has put brush to canvas to begin the actual portrait, Patron advises her that he has changed his mind and is revoking the offer. Your exam asks, what legal rights does Artiste have against Patron? Answer hash 1. Whether Patron can revoke his offer will depend on whether we apply the common law rule or the rule provided by 45 of the second restatement. If we apply 45, there will then be a second issue about whether Artiste's work so far counts as having begun performance. Answer hash 2. Patron can revoke if the old common law rule applies, or even if 45 of the restatement governs, if a court can be persuaded that Artiste has yet to begin performance. Patron's right to revoke under the common law is based on the fact that his offer seeks a performance painting a portrait rather than a return promise. He says he doesn't want a commitment. Thus, it constitutes an offer to form a unilateral contract. At common law, such offers can be revoked any time until performance is complete, and Artiste has not yet finished the painting. Section 45 of the restatement replaces the common law rule with one more favorable to offerees in this context. It will prohibit revocation once Artiste has begun as opposed to completed performance. Patron will contend that since there's no brush to canvas, performance has not yet begun. Artiste will counter that the preliminary sketch work counts as the beginning of performance and is more than mere preparations. Once again, we're sure you'll see that answer hash 2 is superior. To be sure, answer hash 1 has the virtue of spotting the central issues, and as we've explained, that's not nothing. But answer hash 2 is better because it addresses the 2 questions that are the keys to a successful analysis. First, answer hash 2 explains why there's a fork, why the road is split as it is, and it does so both for the fork in the law and the fork in the facts. At the fork in the law, answer hash 2 identifies the facts and reasoning that trigger the rule vs. counter rule situation. Because Patron's offer sought a performance rather than a return promise, it may be characterized as an offer to make a unilateral contract, and the common law rule governing the revocation of such offers, revocation permitted until acceptance is completed, differs from the rule under the restatement, revocation prohibited once performance is begun. In short, understanding the fork in the law not only helps you identify the issue, but it also permits you to explain why there's an issue in the first place. At the fork in the facts, answer hash 2 does the same thing once again. It identifies the facts. Artiste has done sketch work, but has not begun work on the portrait itself that could lead down one road: sketch work as the beginning of performance, as well as another: sketch work as mere preparations. The second successful strategy of answer hash 2 is that it carefully explains what will happen in the dispute between Patron and Artiste if each of the issues is resolved in a particular way. If we resolve the fork in the law issue one way, common law, then Patron can revoke. If we resolve it the other way, 45, then it depends on whether Artiste has begun performance. Patron can't revoke, or undertaken mere preparations he can revoke. Such a focus on ultimate outcomes is so important, we will return to it again later. For now, however, notice how answer hash 2 takes the reader carefully through all these steps and links. It's simple and straightforward when you read it. But you need to learn to do it on your own, which you can if you remember to explain why the road we take at the fork matters to the parties. 3. The recipe for argument construction. Just add reasons. On law exams, analysis is good. Good analysis is even better. And argument is better still. Let's take it to the next level then, and talk about what it takes to move from mere analysis to argument construction. One way to describe the difference is to say that an argument is an analysis that attempts to persuade. That's an extremely useful definition for our purposes, since persuasion of opponents, of judges, of juries is what most lawyers do for a living, and what most law exam questions are designed to test. A concrete example may help you see vividly the difference between mere analysis and argument. Imagine once again that you're an associate in Carla's Texas law firm, and that, as a reward for your brilliant handling of Fred's land subsidence case, she has asked you to work on a case for one of the firm's oldest and most important clients, Arlene Artiste. Actually, you were hoping for a raise, but you're happy with the vote of confidence the assignment seems to represent, and with another opportunity to impress the firm's #1 rainmaker. The case, of course, is Artiste v. Patron, and an hour ago, you gave Carla a memo that reads just like answer hash 2 from the previous section, i.e., the answer that analyzed the issues in the Artiste Patron case, rather than merely spotting them. You've been waiting nervously when the intercom on the phone emits a loud buzz and Carla summons you to her partner-size office with a partner-pleasing view. "This is fine work," she says as you walk in and sit down. "Your memo is very helpful, but you forgot something. Something big, I'm afraid. As I understand it, we have a bit of work ahead of us if we're going to win this one for Arlene. First, we'd have to persuade a court to go with the restatement approach rather than the old common law rule. Then we'd have to argue successfully that Arlene's sketch work was the beginning of performance. Do I have it right?" "Yes, that pretty much covers it," you respond, wondering what on earth she thinks you left out. "So, how are we going to do that? You got cases? Texas cases? Arguments?" "You know, they don't let us pay the judges for ruling in our favor anymore," she teases. "We gotta convince M just like everybody else." She seems slightly amused by your obvious embarrassment at the lapse, and you retrieve the memo and scoot quickly from her office, heading for another long night in the firm library. But if answer hash 2 doesn't tell you how to go about persuading a judge, it certainly does have the virtue of telling you exactly what it is that you have to persuade the judge of. In the same way that identifying the forks in the road offers you a blueprint for an analysis of the question, it also offers you a blueprint for your arguments as well. Your job, if you choose to accept it, is to make arguments for choosing the path of 45 at the fork in the law, and to make arguments for choosing the path of sketch work equals beginning of performance at the fork in the facts. And that's not mission impossible. But you'd better get started right away, for there's almost surely a young associate burning the midnight oil on the other side of town, trying to figure out how to persuade the court to go the other way at each of those forks. A. Keep in mind who the real judge is, the kind of persuasion that lawyers do for a living, and the persuasion that students are supposed to do on exams are alike in more ways than just the one suggested by this story. When you think about it, a lawyer is typically attempting to persuade at least 2 audiences at the same time. Her primary task may be to persuade some decision maker, the judge, the jury, etc., to see the case her way. But for a host of reasons, she's also trying to persuade her client that she's a competent lawyer. On law exams, students are also pitching to 2 audiences, yet here the priorities are reversed. The question may ask them to persuade a judge, or a senior partner, or opposing counsel of this or that proposition. But the real point of the exercise is to persuade the grader that you are doing a good job of persuading the hypothetical decision maker. We can think of no better way to begin that task than by making the arguments that the law professor taught you in the course. If she assigned a series of articles that offered economic arguments on both sides of the contributory vs. comparative negligence debate. Then if you get a question on the exam involving a negligent plaintiff, for heaven's sake use the arguments she's taught you. Similarly, if you spent several classes discussing the virtues of various approaches to interpreting statutes, e.g., a purpose-based approach will further the legislature's aims in cases it hadn't foreseen. But a plain meaning approach will encourage the legislature to draft more carefully in the first place. Then use those arguments when you encounter a competing interpretations question on her final. If the professor hasn't rehearsed specific arguments on a question, consider the larger themes and issues she emphasized in the course. If, for example, throughout the semester your contracts class explored the conflict between the importance of protecting reliance on the one hand and the importance of promoting freedom of action on the other, then don't be afraid to draw your arguments from that resource. To continue with Artiste v. Patron, 45 has the advantage over the common law approach of protecting the reliance of an offeree who is vulnerable to revocation during an extended performance. But the common law rule has the advantage of protecting the offerer's freedom of action until the last possible moment. B. Once again, you already know more than you think you do. 1. Patterns of argument for forks in the facts. Yet another advantage to the forks in the road approach is that many of the patterns we explored in part I lead directly to patterns of argument. This is true in particular of the patterns we explored in Chapter 6 on forks in the facts. Let's look at a concrete example by focusing on the second of the two issues presented in Artiste v. Patron, the fork you encounter if we follow the path of Restatement 45 at the fork in the law, and watch what happens when we make the jump from mere analysis to argument. Answer #1. Under 45, Patron may not revoke once Artiste has begun her performance. Patron will contend that since there's no brush to canvas, performance has not yet begun. Artiste will counter that the preliminary sketch work counts as the beginning of performance and is more than mere preparations. Answer #2. Under 45, the offer may not be revoked once the offeree begins performance, and it's not clear whether Artiste has met that requirement. On the one hand, Artiste can argue that she began the performance when she did the preliminary sketch work. To an artist, such sketches are as much a part of portraiture as the brush strokes on the final canvas, and from that standpoint she began the invited performance at the moment she started work on her first sketch. But Patron can counter that he asked for a family portrait, not a series of sketches in exchange for his promise of tolerantism. From the customer's standpoint, and the customer is always right, the invited performance is the actual painting of the commissioned portrait, and the preliminary sketches were mere preparations for that performance. Answer #1 tells us a lot. It spots the issue: is the sketch work the beginning of performance? It tells us why it's an issue because the sketch work might be the beginning of performance, or it might be mere preparations. And it tells us what difference the issue makes to the outcome of the case. If the sketch work is the beginning of performance, Patron cannot revoke. If it's mere preparations, Artiste is out of luck. But answer #2 looks like Carla got hold of it and, impatient with a mere description of the parties' conflict, began to do what lawyers do, and to make arguments for why the conflict should be resolved one way or another. Note that answer #2 draws on the differing standpoints of an artist on the one hand and a customer on the other to develop the arguments for the parties. In Chapter 6, we cited differing standpoints as one of the common patterns of factual ambiguity that law professors use to create forks in the facts on their exams. As we've said before, if you learn to recognize those patterns, it will be much easier for you spot issues on exams. But the point we want to make here is that these same patterns can also help you construct legal arguments. It is a short step from recognizing an issue depending on your standpoint. Artiste's sketch work might or might not be the beginning of performance to beginning to develop the arguments that lawyers would make for the respective parties, an argument based on Artiste's standpoint vs. an argument based on Patron's. To put it another way, it's an issue precisely because there are arguments on each side of the point. So once you've spotted the issue, the arguments aren't far behind. Just as issues can lead you to arguments, arguments can lead you to other arguments as well. Let's continue with your saga as the associate working on Artiste V, patron. And let's assume that Carla has just read the handiwork you came up with in answer #2. I like this, she enthuses. Standpoint. Is that what they're teaching y'all in law school these days? Never knew there was a name for it, but it really does sort out the conflict, doesn't it? Your confidence returning, you shake your head in agreement and are just about to speak when she continues. But back when was in law school, back before they used fancy pants terms like standpoint, they used to tell us that we ought to start by reading the contract. And if we're trying to figure out whether sketch work is part of Arlene's performance, perhaps it wouldn't have been such a bad idea to start by seeing whether the contract has anything to say on the matter. Well, there isn't a written contract in this case, you reply somewhat defensively. I know that, she snaps. But oral agreements have terms too. What did Paul Patron say when he hired Arlene? You rifle the papers in the file, pull the memo detailing the intake interview with Artiste, and read from it. According to client, Patron said, I will pay you $10,000 to paint a portrait of my family. There was no discussion of sketch work at that time, or at any time before Patron called client to say that the deal was off. Well, Carla drawls, if we're representing Paul Patron, I'd be saying that I didn't ask for any damn sketch work. I asked for a portrait, and she ain't begun that yet. How are we going to respond to that? You return to your office, wondering whether your college roommate who went on to medical school has days like this. Carla's right about what Patron said, you muse. And what can you say in response to an argument as strong as that? Suddenly you remember that somewhere you saw an entire list of responses to arguments like that, and you reach for a book you hadn't looked at since law school. You locate the chapter titled Forks in the Facts, and begin to thumb through the patterns of issues that had helped you so much on your law exams. You hit an entry in the linguistic ambiguity section, literalism vs. reasonable expectations, and a light goes on. That's it, you think. If Patron argues that he said portrait, we can argue that that's just too literal. After all, he's not buying a portrait from an art gallery. He's hiring an artist to paint one for him. And if you read between the lines of the agreement, rather than just focusing on the words Artiste says Patron used the reasonable expectation, is that he wasn't just asking Artiste to deliver a product, but rather asking her to embark on a process that begins with sketch work. Once again regaining your confidence, you read on looking for further inspiration, and another light goes on. You hit multiple sources of meaning and are reminded of the baker's dozen. Wow, you think. When you order a dozen loaves of bread from a baker, you shouldn't be surprised if you get 13. So if you order a portrait from an artist, you shouldn't be surprised to get sketch work first. So even if we're stuck with a word portrait, and we can't read between the lines, maybe portrait has room in it for sketch work. Exhilarated by your insights, you click on your word processing program and start another memo to Carla. Patron can be expected to argue that he contracted for a portrait, not for sketch work. But careful analysis suggests at least two arguments in response. The memo begins. The forks in the road approach thus helps your argument construction efforts in a second way. If the point of our earlier discussion was that a fork can provide a blueprint for developing opposing arguments, the point here is that the same blueprint can help you see a counterargument and hence an issue that could be resolved in more than one way when at first you see only one side. To be sure, when you're taking an exam, you won't have a Carla looking over your shoulder saying, "But the contract says so." But we'll let you in on a little professorial secret. Most exam questions are written so that the argument on one side is pretty obvious. For that's how we separate the merely good answers. They see the obvious argument and know exactly where to go with it from the excellent ones. They figure out a way to respond to the obvious argument. And we think that the key to seeing the counterarguments, to knowing that you can respond to a literal argument with a reasonable expectations or a multiple meanings response, is a thoroughgoing familiarity with the patterns we explored in Part I of the book. That is why we've offered so many concrete examples and illustrations drawn from different topics covered in different courses. You need to make these patterns your own by learning to recognize them when you see them in operation in a new setting. Indeed, your ultimate goal to ensure success in law practice, as well as on law exams, should be to learn to recognize new patterns when you encounter them as well. 2. Patterns of argument for competing interpretations of statutes and cases. The forks in the road approach is likewise very helpful in dealing with competing interpretations of statutes and competing interpretations of case law. For once again, the patterns we studied in part I lead to patterns of argument. So it is typically the case that merely by identifying the issue, you have also produced a blueprint for your argument. Indeed, in one sense, developing arguments in this context may be even easier than it was with our forks in the facts, because the positions taken by lawyers in this setting are so familiar that they typically present themselves as arguments, e.g., plain meaning, broad holding, and all you have to do is apply them to the particular context. There's the rub, of course, because applying these arguments to a particular context will typically require a detailed knowledge of the language and structure of the statute or of the facts and reasoning of a case or a line of cases. You can't make a plain meaning argument if you don't know what the statute says, and you can't argue for either a broad or a narrow interpretation of a case you haven't studied carefully. No matter how good you get at these arguments, you can't deploy them effectively unless you first have a solid grasp of what it is that you're arguing about. C. The crucial role of policy arguments. There is a vitally important dimension to argument construction that we haven't focused on yet: policy argument, a dimension so important that we have devoted all of the next chapter to the topic. Law students frequently make the mistake of thinking that policy arguments should be made only in the context of questions that present themselves as policy questions, e.g., you are a legislative aide to Senator Smith, and she has asked you to prepare a memorandum discussing the pros and cons of a bill that would amend the National Labor Relations Act to add the following provision. But in fact, policy arguments have an incredibly important role to play in each of the kinds of issues we've been exploring. Indeed, in the typical rule vs. counter rule problem discussed in Chapter 3, where, for example, the facts are set in an imaginary jurisdiction that has not yet decided whether to follow the traditional common law or the restatement position on some issue in torts, policy arguments are frequently the only arguments available, since you can't rely on a statute or a precedent or the facts to resolve the parties' conflict. And when you confront forks in the law that involve issues of interpretation of either a statute, Chapter 4, or of case law, Chapter 5, you'll find that you need policy arguments more often than not as well. Recall, for example, that many issues of statutory and case law interpretation are really arguments about how to further this or that policy or how to deal with competing purposes or policies, in other words, policy arguments. Finally, even the application of statutes and cases to facts involves an important element of policy analysis. Recall, to take only the most dramatic example, our hidden forks problem from Chapter 7, where the question presented was whether the result, the family loses its farm to the corporate tenant, was consistent with the policies that prompted the legislature to enact the landlord-tenant statute. The family had nothing to go on but policy, so if you'd ignored that dimension of the problem, you would have had no issue to discuss. 4. Where to focus your fire. In the general test taking tips appearing in Part Roman 3, we devote substantial attention to the problem of dealing with time constraints and credit allocations on a law exam. But because the issue spotting questions we've been discussing raise special difficulties in this connection, we thought we'd take a moment to address them here. A. Focus your fire on points in conflict. Assume you encounter an exam question involving the application of a state whistleblower statute to a complex fact pattern. You whip through the pertinent section of your course outline and are thrilled when straight away you see 4 different points implicated by the facts. First, there is a provision requiring would-be whistleblowers to notify the employer in writing before disclosing illegal conduct, and the facts reveal that the employee in this case gave firm officials only a 1-page photocopy of the statute the employer has allegedly violated. Is that a notice in writing? You wonder. Next, there is a provision stating that notification must be made to a supervisor, and a related provision defining that term, and the facts reveal that the whistleblower gave the photocopy to the firm's general counsel, who may or may not be a supervisor under the statute's definition. A fork in the facts. Then there is a section prohibiting discharges in retaliation for whistleblowing, but permitting employers to fire employees for cause. And the facts suggest that the employer here was motivated both by the whistleblowing and by the employee's terrible record of tardiness. Didn't the professor call that a mixed motive question? Finally, there is the jurisdictional requirement of the statute. A firm must have 10 or more employees to be covered, and the facts state that there are 25 employees. Gotcha. You have an hour to draft and answer 45 minutes. Now that you've read and reread the facts and worked your way through your course outline, so where will you begin? We've read enough exams over the years to know that the first instinct of some will be to lead with the jurisdictional requirement. Even though most law students profess to suffer from math anxiety, it's amazing how much they love to write answers carefully explaining that 25 is much larger than 10. To be sure, there's nothing wrong with addressing the jurisdictional requirement in these circumstances. For one thing, meeting it is crucial to the application of the statute. For another, the professor gave you a fact in the question that satisfies that requirement, but resist the temptation to expand your treatment beyond a sentence or two at the most, e.g. The requirement of 10 employees under 1D14 is easily met by the fact that the employer has 25 in a misguided effort to rack up points on a topic about which you feel confident, e.g. the difference between 25 and 10. The history of jurisdictional requirements. The successful efforts of the small business lobby to exempt its members from various employment statutes in order to put off addressing topics with which you feel less comfortable, e.g. the notification and mixed motive issues. To put the point in terms of forks in the road, the professor is almost surely testing your ability to address the issues in the question, about which there is genuine dispute and arguments to be made on both sides, and not your ability to tell whether 25 or 10 is the larger number. B. Focus your fire on points that make a difference. Let's continue with our whistleblower example, and assume that, upon carefully rereading the facts, you realize that the whistleblower gave photocopies of the statute to both the company president and the general counsel, who happened to be in the president's office when the whistleblower dropped by. You've still got a fork in the facts. The general counsel may or may not be a supervisor under the statute's definition of that term. But before you're off on a lengthy disquisition about the facts pointing each way, force yourself to ask, what difference does it make whether the general counsel is or isn't a statutory supervisor? If the general counsel were the only individual to whom our whistleblower gave the alleged notice, then the general counsel's status would obviously be a vital issue. But on these facts, since the whistleblower gave a copy to the company president as well, and there's no question that she's a supervisor within the meaning of the statute, the general counsel's status will make no difference to the outcome. To be safe, of course, you might devote a sentence or two to identifying the issue, and even the key facts that create the ambiguity. That way, you're sure to get any issue spotting points the professor is giving out. Far more important, you should briefly explain why the general counsel's status doesn't matter. Chances are that will get you more points than any discussion of whether LAVSers are supervisors. But any more than a few sentences and you're twice a loser. You lose once because you've wasted time better spent on issues that do make a difference. And you lose again when the professor reads your answer and wonders why you gave extended treatment to an issue that wouldn't affect the outcome, no matter how it was resolved. C. Focus your fire on issues emphasized by the professor. The good news is that you've figured out that the jurisdictional requirement isn't really an issue, and that the general counsel's status doesn't really matter. The bad news is that your answer so far consists of 2 extremely short paragraphs making these points, and you've now got only 30 minutes left on a 1-hour question that's worth 25% of the exam grade. There are 2 issues left: the notification issue and the mixed motive issue, and you estimate that you could easily spend an hour writing on either of them. What will you doff? Whatever else you do, You should start out by writing a roadmap paragraph that briefly describes the two analyses you plan to give. The professor can't give you credit for insights that don't appear in your blue books. And by proceeding this way, you offer yourself some protection against the prospect of running out of time before you reach the second issue. But which issue should you tackle first? To resume a theme mentioned earlier, remember who your real judge is, and that chances are she is trying, as most law professors do, to test what she taught you. So, what did she teach you? If she devoted a substantial portion of the course to close and careful statutory interpretation, and if the notification question requires an involved analysis of the sort she repeatedly forced students to undertake in class, then you'd be wise to use the opportunity to show your statutory stuff. On the other hand, if a major theme of the course was the problem of mixed motives in employment law, then perhaps the exam question is the perfect vehicle for bringing that theme to a close analysis of particular facts. Either way, the point is to let the professor rather than the luck of the clock be your guide in making your triage decisions. Right till the facts run out. We close with a very important point, but one we offer more as a caution than a finely detailed prescription. On most exams, you simply won't have time to discuss every ambiguity you see. Indeed, getting to maybe has prepared you to find ambiguity everywhere you look. If you understand that the twin fork is the basic technique in almost every exam, then you see that it's a short step to long questions that involve multiple forks. If there are 3 relevant statutes and 2 relevant cases for your problem, then even if each has only 2 plausible interpretations, you have already 32 different combinations to discuss. Trust us on the math. You are sure to tie yourself in knots if you go down every path. Accordingly, you need strategies to ensure that you aren't discussing an ambiguity that the professor won't find relevant to the test. We've just suggested several strategies for accomplishing this. Focus on disputed issues. Focus on issues that matter. And focus on the points emphasized by the professor in the course. But we have one more suggestion for keeping on track. Use the fact pattern as your guide. Although some facts are in there for color, and some professors throw in extraneous facts, we call them red herrings, the exam question will mostly contain facts that are in there for a reason. So, if you find as you write that you are considering additional issues that are raised by particular facts, you are probably on the right track, and you should keep writing until these facts have been thoroughly analyzed. By contrast, if you are turning to new issues merely because they are prominent in your course outline, or worse still, if you find yourself continuing to invent issues based on what-ifs, chances are you are tying yourself in knots. Stop. Take a deep breath and turn your energies elsewhere. See what not to do with issues. Herein of Iraq. Cards on the table. In our combined quarter-century of law teaching, and in the thousands of blue books we've read over all those years, neither of us can ever recall seeing an exam answer organized around the so-called Iraq method, issue rule application conclusion, that was truly first-rate. Not a one. Indeed, a former colleague puts the matter well when he warns his first-year law students that those who use Iraq tend instead to come up with Iran, issue rule application nothing, and that this makes the grader irate. And the last thing you want your answers to do to the person faced with the formidable task of grading 100 or more sets of blue books is to make her irate. We readily acknowledge that we may be dealing with a skewed sample here. Since we urge our own students to avoid Iraq like the plague, it may well be the case that the Iraq-based exams the two of us encounter are written by individuals who have ignored other important things we've said as well. Moreover, there is nothing wrong in principle with an approach to exam taking that encourages students to organize their answers around issues, and to take the pertinent legal rules and principles they've studied and apply them to the facts presented in the question. Indeed, in broad outline, that's roughly analogous to the approach we've recommended here. If students drew those lessons from Iraq, we'd have no quarrel with the notion of using the method as a base from which to develop even better and more sophisticated exam-taking skills. But judging from the many applications of Iraq we've actually encountered over the years, most students seem to learn 2 other far less salutary lessons instead. The first one is that Iraq is the law school equivalent of the veg-o-matic. There is no exam question, no matter what its shape or size, that you can't slice and dice with the help of this handy-dandy little tool. But in point of fact, Iraq is designed for a particular kind of exam question, albeit a very common and important one: the issue spotter. And deploying it in the context of one of the many kinds of questions that don't follow the issue spotter format almost invariably leads to unmitigated disaster. We're going to address this aspect of the Iraq problem at some length in the test, taking tips appearing in Part Roman 3. We'll focus here on a second lesson that Iraq unfortunately seems to impart: the belief that you can reduce legal analysis to a simple 4-step formula. But that dog just won't hunt. For even in the context of the traditional issue spotting question for which Iraq is designed, the formula is as likely to mislead you as it is to enable you to construct a quality response. For one thing, following the order of operations suggested by the acronym 1, spot the issue. 2, identify the rule. 3, apply the rule to the facts. And 4, offer a conclusion can get you into serious trouble. Thus, many issues appear only after you've first identified the pertinent legal rule. For example, an oral contract for the sale of goods at a price of $500 raises an issue under the statute of frauds, but identifying UCC 2201 as the applicable rule may itself raise many more questions than it resolves. Although there is no written contract, is there a check or a letter or some other writing sufficient to indicate that the parties have a contract? Did the disappointed party send the reneging party a confirmation of the deal prior to breach? Are the goods specially manufactured? Have any of them been delivered or paid for? Similarly, Iraq identifies the conclusion as the final step in your answer. But often it is only the beginning. Thus, when the application of a rule to the facts brings about a conclusion that is utterly at odds with legislative purpose, recall our hidden forks about the corporate tenant trying to take over the family farm. The professor may well be testing to see whether you are able to make a lawyerly argument for circumventing rather than merely applying the rule at issue. An even more fundamental problem with Iraq is the unstated premise that there is but one rule and but one way to apply it once an issue is spotted. The whole point of Part I of this book is that many exam questions raise issues that could be resolved different ways under different rules, e.g., contributory vs. comparative negligence. Under competing interpretations of the same rule, e.g., plain meaning vs. purpose-based interpretation of vehicle. Or under competing interpretations of the same case, e.g., broad vs. narrow readings of Hawkins v. Magee. And even if we are able to settle on a single rule or a single reading, the task of applying it to the facts is similarly complex. Indeed, we devoted an entire chapter to examples of problems that would come out different ways under competing factual interpretations. In the same way that the parties may disagree about the rule or about its application to the facts, they can, and in the real world, they frequently do disagree about the issue presented by the problem. As suggested in the section on competing domains, law exams frequently test your ability to see that more than one body of law and hence more than one issue might be implicated by a single problem. Recall how useless Iraq was in the debate among the associates discussing the land subsidence case in Carla's Texas law firm. Disagreements and conflicts, such as these, are the heart of most exam questions, and you are likely to miss them altogether if you read the questions through the distorting lenses of Iraq.